Earlier this month, Banner Health announced a data breach affecting 3.7 million individuals. In late June, Banner discovered that intruders may have gained unauthorized access to the computer systems that process payment card data at certain Banner Health food and beverage outlets. 2 weeks later, Banner discovered that the intruders may have also accessed patient and health insurance records. Now the company is facing several potential class action lawsuits over the incident. On today's Cyber Chat, we talk with Michella Kras, one of the attorneys working on the Banner data breach case filed by Hagens Berman Sobol Shapiro. We discuss the specific case, how data breach lawsuits can motivate organizations to improve security, and what companies can do to limit their potential liability. And I'm wondering if you could maybe touch on the specific issues in this case, why there is a lawsuit over this. Because we see so many different data breaches in the news, and there's a lot of data breach lawsuits. So I'm wondering if this is a pretty typical case or if there's anything unique about it.
I think this one's a little more unique just because of the healthcare aspect of the case, that the health insurance information was taken. So I think the easiest kind of data breach case would be one where just credit card information was taken, because obviously you can go out and cancel your credit card. A lot of the credit card companies will even catch that if somebody's making fraudulent charges. So that one's fairly easy to remedy if they don't have any other information about you. But when they start to get all of your personal information, including social security numbers, that's when it becomes kind of goes to another level, because they can use that information for years. So, Banner here offered 1 year of credit monitoring so you can kind of make sure no one's opening accounts or using your identity. But once they have that information, who's to say they're going to use it in the next year? Maybe they'll, they know these attackers, these hackers, they know that these companies are going to offer a year of credit monitoring. That seems to be kind of the thing that they do to try to make it go away. I'll just offer you a year of credit monitoring. So all they have to do is wait a year, and then they can use that information. And, there's, especially in a case this large with 3.7 million people, that's pretty valuable, and they can use that down the line. This case was even more interesting to us because of the healthcare information that was taken. So they have people's health insurance information. So there could be health insurance fraud. Now people have to monitor, their explanation of benefits that they get from their insurance company to make sure nobody's receiving services using their insurance information. Same thing with, obtaining prescriptions. And then, of course, with the provider's information being taken, people could go out and get, prescription drugs, a lot of those drugs that are monitored, things like fentanyl or, other opiates that can kind of flood the system. And people would obviously be interested in being able to go out and get false prescriptions for those and without any consequences. So that's kind of why we thought this was an important case. I know it happens a lot, these data breach cases, and so people kind of become wary of them. But when they do happen, particularly in a case like Banner, where they've got very sensitive information that they need to be protecting, and obviously we haven't done any discovery yet, so we don't know what their security measures were, but it seems to be that they were inadequate. We think that Banner needs to do more, because they're putting the onus on their patients and their employees to, monitor their own health insurance information, because credit monitoring isn't going to protect that. And they're only giving them a year to have that credit monitoring. So who knows, if something happens in the future, Banner hasn't done anything to protect them.
Yeah, I wanted to ask you about that timeline. You were talking about how sometimes cyber criminals can, they can just wait a year and then they can do some kind of fraud or something. And I was wondering how that plays into the whole issue with having to establish standing and prove that there was some harm. Because I saw an article, I think it was in June in the Wall Street Journal, and I think the title of it was, "For Consumers, Injury is Often Hard to Prove in Data Breach Cases." And they said that although more than 1/3 of breach lawsuits in 2015 targeted healthcare companies, a lot of those, as well as in other industries, end up getting dismissed. So just wondering your thoughts in general on establishing standing.
Sure. So there is a split among the circuits on whether or not an individual has standing in a data breach case. It's been our position in other cases that we've done that they do have standing, that there is an injury there, because if a consumer has to go out and buy that protection, or they have to spend time, going through their medical records, or in the case of our doctor, he's got to take time out of his busy day to monitor his provider ID and DEA number to make sure that nobody's using those fraudulently, that's time and money out of your pocket. So those are damages. I mean, the fact that it's been put out there, we think that a individual has been damaged. Now, there are some courts, not in Arizona, and no federal courts in Arizona. We're in state court, but there's no courts in Arizona that have gone that far to say, oh no, there's no damages because you haven't suffered injury yet. Some courts are requiring you to show that your information was actually used and tie it to that particular breach, which is a pretty hard bar to overcome, and kind of lets those companies off the hook for just being sloppy with their computer databases and not putting in the protections that they need to.
I don't really get a chance to speak with a lawyer very often, so just wondering if you could maybe fill us in on how class actions just work in general. Because, for example, in preparing for this interview, I went on the Pacer website and I found there was 2 other complaints filed against Banner Health in August. And so it seems like every time there's one of these lawsuits, there's, different states and different law firms are filing these different complaints and class actions. So wondering if you could just explain, the process or timeline on a class action like this and how that comes together and how it works with so many different players.
Sure. So for your listener who doesn't know anything about class actions, basically, the class action device is made to when there's a lot of individuals who have suffered a harm, but individually it wouldn't be worth their time and money to go to court against a large company. The court allows them to join together and bring an action against a company. Like most people are, even though their information was taken, they didn't have the resources to go out and sue Banner on their own to try to get, a couple $100 worth of recovery. So the class action device is something that the court systems have put in place to allow individuals to group their claims together. They can be represented by one or maybe a couple different individuals who are in the same position as them. So that's kind of how class actions work generally. Sometimes you will see multiple class actions filed in one case. And so different things can happen in those situations. We chose to file our class action in state court because most of the Banner hospitals are in Arizona. The information was housed in Arizona. Most plaintiffs, at least we believe that 2/3 of the class members will be in Arizona. So we felt like it made sense to file it in state court because we think it's kind of an Arizona, more of an Arizona matter. We know some other firms have filed in federal court, and then, Banner will treat each case individually. They may decide to try to work out a global settlement among the different cases. Sometimes when multiple cases are filed in federal court, and if they're filed in different districts, the district court might consolidate those into one case, which can take a little longer. That was the other reason we decided to go with state court, is they tend to just move a little faster. Arizona state court moves a little bit faster than a federal court would, and obviously with a case like this, the more time that goes by, the individuals who had their information taken are waiting to get more credit monitoring, or it's not in the best interest of the class to have more time go by. So that's why we chose to go with state court. We thought it was a case that was appropriate for state court, and we believe that we'll be able to conduct this discovery faster and hopefully, either go to trial or work out a settlement with Banner on a faster time frame than those cases that were filed in federal court.
And most of our listeners, they tend to be more security or cyber risk management types of people. And obviously, they're listening from the perspective of they want to avoid, being in a breach lawsuit like Banner is. Just wondering if you have any advice or things that kind of come to mind on how they should go about staying out of harm's way.
Well, I think, I'm certainly not an expert in that area, and that's the type of thing that we would hire an expert for, to go in and look and see what they had set up and whether it met the, standards that we think need to be in place to protect your data. But I think the thing to remember is that companies cannot just assume that the protections they have in place are good enough. They shouldn't just go with the status quo. If they don't have the individuals in-house who can look at that and decide, be able to analyze whether their protections are good enough, then they probably need to get an outside, firm to come in and look at and identify any weaknesses that they might have and make sure to correct those. And I think that's something they need to do, every couple years, because, technology is always changing, and these hackers are always going to be looking for new ways to get into these secure databases. So I think that would be my recommendation of the best practices. And I think that's going to, if a data breach does happen to a company, they can point to these things that they tried to do, which would, limit their liability. They're going to say, we weren't negligent. We did everything that we could. Here's the best practices. This is what we did. And so that might insulate them if something does happen.
And then my final question is just looking forward at the data breach lawsuit scene kind of in general. There was a quote I read from Robert Carey, a partner at the firm. He said that healthcare people should be on the front edge of how to protect systems in leading the charge, and the lawsuit will help to incentivize that improvement. He was talking about this lawsuit at Banner Health. And then he also said there has to be a great enough cost on the back end to motivate people to do the right thing on the front end. So just wondering, we interview people in the cybersecurity space all the time. So curious to hear from a legal perspective about that. Do you get the sense that from talking to people or working cases like this, that there still needs to be a bit more motivation in terms of these successful lawsuits in order to push security forward?
I think there does. I think that there needs to be. We deal with a lot of class actions, just not in the data breach arena, but across the board. And what we see is that a lot of these big companies don't do the right thing until they're kind of forced to, or they see it happening to another company. So, people, they think maybe they can get away by, for example, with Banner offering your credit monitoring. Well, I'll offer your credit monitoring. We'll work out a price with Kroll. I'm guessing they probably paid $6 per person. So for them, that's a pretty cheap cost to get rid of this, assuming that would work. But if they had just taken better actions on the front end to secure their data, then, this wouldn't be happening. But the fact is that they're paying $6 per person who actually goes and signs up. That's not much of an incentive for them to change their practices, because, it's such a small amount to a company that big, it doesn't affect them. So it needs to be something greater than that to kind of spur them to make changes. And I don't know why that is. Maybe it just comes down to a cost-benefit analysis for some of these large companies, but that cost-benefit analysis isn't going to change until they realize that it's going to cost them more on the back end, I believe.
And that'll wrap up this episode of the Cyber Chat Podcast. The Cyber Chat Podcast is brought to you by Surfwatch Labs. Surfwatch Labs helps organizations and service providers quickly establish a strategic cyber threat intelligence operation that drives more effective use of their tactical defenses. For more information on cyber risk intelligence, check out surfwatchlabs.com.